everyone. It's been a while. I hope you guys have been doing well. We are here. We're live. We are streaming. We're covering Karen Read. We covered the Karen Read trial. And if you guys remember, this was like back in I think early of July, where she's accused of murdering her boyfriend, John O'Keefe. John O'Keefe is was a Boston police officer at the time. And, we watched the trial. It was a mess. It really was. Probably one of the most messiest trials I've ever seen presented by the state so far. It was kind of all over the place. When the experts went on there to testify, I just felt like the experts were just, some of them that were very pivotal to the case, I just thought they weren't qualified, especially the crash reconstructionist, Trooper Paul, I think that's what his name was. Sorry. Oh God, it's so super early. So yeah, we're here. We're back again. The jury, it ended up in a hung jury. The judge sent them back multiple times. They couldn't deliberate. They couldn't decide. Oh, hey, Trail TV. What's going on? How are you doing today? Hello. Oh, wait, you're on Twitch. Hello. What's up? Hi, Val. How are you doing today? You're thinking of me randomly and you went live? Well, hello. Good morning. Yeah, go back to sleep. It's too early. It's 7 a.m. right now. So her trial is slated for January of 2025. Now, both sides, the state and the defense, they want to move it, I think, to April. They just want a couple more months, especially because Mr. Adam Lawley, who was the, state prosecutor who was prosecuting this case, he is no longer the lead. It is now going to be Mr. Hank Brennan. And interestingly enough, Mr. Hank Brennan represented Whitey, I think that was his name, Whitey Bulger. And what's interesting about that is because we watched a Johnny Depp movie like a couple years ago after the Depp v. Heard trial. We were like binging like Depp movies. And he represented the character that Johnny Depp played in this movie called Black Mass. Really, really sad movie towards the end. But yeah, if you guys feel like it, feel free to check it out. Yeah, good morning. Hello, everyone. Now, just a reminder, this case is very divisive. So be nice to each other. Disagreements, welcome the chat. But guys, let's be fucking civil, because sometimes things were getting a little bit heated on both sides. And I just wanted to ask you guys, just be civil, right? Let's just be good. Let's be civil. And if there's anyone that you don't like, hit the block button, okay? You don't need to listen to them. You don't need to read their opinions. Just hit the block button if you really can't stand them. And yeah, we're going to get into the Karen Read trial. Now, I wish I started a little bit earlier, but you know what? We can catch up. The trial is just starting, or not the trial, the hearing's just starting right now. So what we are doing for the Karen Read hearing today, let me look at my notes. This is a hearing for Rule 17 motion. Rule 17 discovery. Okay. Issue subpoena to provide evidence from third party, out of control from the Commonwealth. So the Commonwealth does not have this evidence. So who are we getting evidence from? If you look at all the stuff for the Karen Read case right now, there's a lot of subpoenas for other companies. And these are companies that Karen Read sat down and did like interviews with, whether they're like maybe like paper interviews or whether they're like TV interviews. And the state's like, yeah, we want everything. We want everything that she said to you. We want the communications. We want the emails. We want the actual recording. So I think they, obviously want to use that to see, okay, well, what are the discrepancies in her statements? Let's see if we can use them against her. And again, remember, she didn't testify in court. She didn't need to testify, but we don't have any recorded interviews with Karen Read, any interactions. There are no body cams. We just didn't have a lot in this case. And it was just like, oh, why didn't you record this interview when you did an interview with blah, 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 blah. It's just like, oh, well, because we used a different room and that room didn't have, recording or something like that. I don't know. But yeah, we don't have body cams really. We don't have any recordings, no interaction with the Karen Read. We have heard from Karen Read because she has done some interviews. I think her father has done some interviews as well. They also do want the text messages, phone communications of her parents. I saw that was in there as well. And what else was in there? Oh, emails. They want the emails of Mr. Morrissey. Mr. Morrissey, who works at the state prosecutor's office. Apparently there's some communications going on with Mr. Morrissey and the judges. And I will try to dig those up because I'd be very interested to read those communications. But hello. Good morning. I think I could have done better for the recap so far. But like I mentioned, the trial is slated for January 2025. Both sides wanted to have it pushed to April, which I think it's fair. We just had a new state prosecutor, who is, I think he's a special state prosecutor. I think he was brought in specifically for this case. You know how they have like special judges, special state prosecutors, like Carrie Morrissey for the Baldwin trial. She was a special prosecutor. Basically, you bring someone in for some, like maybe like a private attorney or someone from a different district, and you bring them in and they work with the state. But yeah, we're going to listen to the hearing and let's see how many different attorneys are going to be in this room, because I think we're going to get different attorneys from all the different companies that are being subpoenaed in here. So let's see how long it's going to be. But I hope you guys are well. Unmasked Reality, Tim, Daisies, Lori, Meow Meow. I hope you guys are doing well. And I was going to stream last week, but I was waiting on some stuff that never came in. So I was like, you know, I'm going to continue spending my next rest of the week just researching stuff. So I'm catching up with a lot of the Koberger stuff, a lot of the Corey Rich and stuff, and yeah, it's a lot, and catching up with all the Karen Reed and stuff as well, because I've just been really busy with the Sarah Boone stuff. And reminder, Sarah Boone's sentencing is going to happen next week. I believe it's going to be next Monday. Yes, next Monday, December 2nd. So I will definitely be seeing you guys there. Have fun, Trial TV. Thanks for popping in. Shout out to Trial TV, y'all. Moondog, hello. Good morning. Good morning. And Go Lucky, hello. Yeah, go back to sleep. All right, let's listen to Karen Reed. Miss Reed is here. I need to catch up a little bit. Let me get my stuff. Oh, you know what I don't have on my screen? I don't have the YouTube chat. Usually I have the YouTube chat nice and big on my screen. That way I don't have to squint to see the font. Give me a second, and then we'll do the catch-up. So we have Mr. Yannetti there, Karen Reed's attorney. Oh, I do see that Karen Reed has added a new attorney to work with them. There's a new attorney. So she already has Mr. Yannetti. She has Mr. Oh my God. How could I forget the other attorney's name? Hold on. I know his name. But I think Elizabeth Little, that was her just now, who's sitting right next to Karen Reed. So Elizabeth Little, Mr. Yannetti. I think it's because he's not here right now. I can't see his face. But I know his name. What's the other attorney's name? Give me a second. It's hard to multitask sometimes. I'm getting the chat up. Okay, I got the YouTube chat. Hello, good morning, good morning. Does she have money? I believe she probably does have money. Maybe her parents helped her out. However, to go through a second round of trial, woo! I know that there were people that were crowdfunding for her as well. So I'm sure that helps. Oh, there's Mr. Lolly. Good morning, Mr. Lolly. How are you doing today? Oh, Mr. Lolly. Mr. Lolly. Where is Mr. Brennan at? Alan Jackson. Thank you. I know his name. You know how sometimes when you overwork yourself about remembering something and then you completely just like roadblock your brain? That happens to me. It's like you over-psych yourself. All right. Mr. Yannetti. Karen Reed's parents are here. Parents that I mentioned earlier, they're trying to subpoena their phone records. I don't believe mom has done an interview. I'm not too sure. I know dad did do an interview. I think this is Karen Reed's brother. I saw John O'Keefe, the victim in this case. He was in here earlier. Oh, there he is. That's John O'Keefe's brother. It's Karen Reed walking in. New special state attorney here, Mr. Brennan. She sold her house for... Oh, yes. I remember that, too. There's a house that she had and sold. All right, Mr. Yannetti talking to Mr. Brennan. Oh, you know what's going to be interesting? This is what they covered in the last hearing. Good news. So for those of you guys who did watch the trial, like I said early in this stream, I mentioned that they had Mr. Paul Trooper, Mr. Joseph Paul Trooper? Trooper Paul? I'm butchering his name. I'm so sorry. There were so many witnesses, and some of their names had like first names, and it was like first name was their first name was their last name, and I'm getting all mixed up. But I think it was Trooper Paul. Trooper Paul was like the crash reconstructionist guy. And here's the good news. I don't believe they're going to use him anymore. I don't believe so. They have a new hired expert, Mr. Shannon Burgess, who is going to be who's going to be taking, I guess, like the chips off the Karen Reed. Is it the informatics? I think the informatics and the telestream. So they're going to take the chips off, and again, they're going to try to get the data from that. And not only that, but they also mentioned they hired a new crash reconstructionist or accident reconstruction expert. So that was very important because you know who testified for the defense? They had the guy that worked for the feds that testified for the defense. And it wasn't like the defense hired the feds. It was because the feds was they were already investigating this case. And so when you had a hired expert that worked for the FBI that went up there and testified, you know, we knew he was from the FBI and we knew why the FBI was involved. I don't think the jury did. I don't believe the jury did. They kept referring to the other hearing, the other special hearing multiple times, but I don't believe the jury knew that was like the federal hearing. All right. Let's see. Is Judge Cannoni here yet? I think we're waiting for Judge Cannoni. This is John O'Keefe's mother. I think that's Aiden Kearney in the... I think that's him. Okay, cool. Well, we're waiting for Judge Cannoni. She's not even here yet. Not even here yet. Mom sat with dad during his interview. Oh, did she say a little? Okay. I haven't seen, because I know that there were new interview footages that came out, I think, after the trial. I haven't seen those yet. I've only watched the ones that were available on YouTube before the trial started. Oh, thanks, Reality. She took out two $200,000 second mortgages on her home during, the first trial. Yeah, I mean, she's got top attorneys representing her case. You know, we have Mr. Yannetti, who is local in Boston. It's always good to have a local attorney there. And then Mr. Alan Jackson is from LA. And her new attorney is from New York, I believe. Okay. New York. Elizabeth Little. I'm not too sure where she's from, actually. Not too sure where she's from. Good morning. How is everyone? How have you guys been? Hi, Taxi. Hello, hello. We're just waiting for Judge Cannoni to come in. Judge Cannoni. Did you guys watch the... and I wish I watched it with you guys, but did you guys get to watch the appellate court? So right now, because it was a hung jury, but here's the thing about the hung jury. I guess I should have mentioned this earlier. I'm sorry. Karen Reed is charged with second-degree murder. Second charge is manslaughter while operating a vehicle under the influence of liquor. And then the third charge, leaving a scene resulting in death. So the jury, it was a hung jury, but then afterwards, the jury were like, well, actually, we all decided unanimously that she wasn't guilty of second-degree murder. What we were stuck on was the manslaughter. We were stuck on the manslaughter. And so when there were people of the jury that contacted the defense afterwards, the defense was like, wait a second, hold on. Then you guys can't go after her and charge her for second-degree murder then. You know, technically the jury decided that they didn't want to, they didn't believe she was guilty of second-degree murder, right? But with how the verdict form, or how, I don't know, it's like a really weird technicality, because although it was like technically not recorded and they may have discussed it behind closed doors, that wasn't communicated to the judge. It wasn't communicated to the judge, and it was probably because maybe they thought the judge was going to ask more inquiring questions, and when the judge did it, they were just like, oh, okay, I guess that's it. But we did have people who served in the jury that, emailed the defense. I think there was about 5 of them that emailed and was like, hey, we don't think she's guilty of second-degree murder. And they went back to Judge Cannoni and was like, hey, you guys shouldn't be charging her with second-degree murder. Sorry, you guys in the state shouldn't be charging her, not Judge Cannoni specifically. That was denied, and then that elevated to the appellate court. And I got to see the beginning of it because I was going to watch it with you guys, but I wanted to catch up more of the case, and I didn't get a chance to. That was like about 2 or 3 weeks ago. But it's very interesting to see how things work in appeals. I think it was appeal court. But basically, you have a panel of judges, and they just fire back all these questions right back at the attorneys, and it's like cool to see like the ping pong, like ding 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 ding. Is this the motion here to determine whether she will be tried again? That one has already been denied by Judge Cannoni. but that's already in the decisions of the higher court. They will make that determination. They had that hearing about 2 weeks ago, and that's the one where I'm like, oh, there's a bunch of judges sitting up there, and there's like a ping pong, like a bunch of questions asked back and forth, and that was very interesting to see because I haven't seen that before. However, the jury, consisting of 100% laymen, know they were supposed to brief the judge and all the fine details. Well, I think technically they don't. It's just like, hey, have you guys came to a decision yet? I think, because here's the thing, when you're working on the verdict form, that's done by the state and the defense, right? But technically there is no verdict form to be filled because they didn't have a verdict. And I don't believe that if there's a hung jury, I don't believe that they really question into like, okay, well, what are your thoughts on charge 1? What are your thoughts on charge 2? What are your thoughts on charge 3? I don't think they technically do that. But at the end, I mean, the defense had a chance to speak out. I don't know if they could have been like, well, could we ask the jury what they thought about charge 1 if they even decided charge 1, right? I think at the end, the judge was like, okay, well, I think she dismissed the jury. She's like, well, thank you for your service. And then the defense and the state had a moment to like speak out to the judge if they wanted to. But I think that's just something that's just like, it usually doesn't happen. So it's something you wouldn't even think of. All right, Judge Cannoni's here. I might have to boost the audio, but you know what? I think Law and Crime and Court TV, they've been boosting their own audio. You are unmuted.
Thank you, Mr. Clerk. Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth, along with me is Attorney Adam Lally and also Attorney Laura Floyd.
I boosted the audio, but if Law and Crime decides to randomly boost the audio on their own, it might get really loud, okay? I'm just letting you guys know.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McCarthy.
Can y'all hear?
Good morning, Your Honor. Elizabeth Little appearing on behalf of defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, everyone.
All right.
Okay.
That's correct.
All right. Good morning, Mr. Jackson.
You dialing in.
We have several motions this morning. Let's start with motion for admission pro hac vice that you filed. And Mr. Unetti,
That's for, I think, the new attorney that's representing Karen Reed.
I know these are freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that
He's the attorney that I mentioned earlier that practices typically in New York.
would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
Right, of this criminal nature. He has represented criminal defendants throughout his career.
Okay. All right. Thank you. All right, so let's go on to the discovery motions. We'll start with the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
Why are we in court today? A lot of this is for discovery. They want to have Mr. Reed is Karen Reed's father. They want to have like the phone access, like the phone calls, the text messages between him and his daughter. I believe they want the same thing for Karen Reed's mother as well. And then there's all the interviews that she did with like some of the station, like I think news company. There's like paper interview, TV interviews. I think they want to have all of that. They want to have text communications, email communications that she's had with the people that work there. And then also the recording as well, if there is any, and everything that she said at those interviews. They want to probably try to see what her statements were, if they were consistent, and try to use that against her because she didn't testify in the trial. Oh, and I don't know if this is where they address the state prosecutor, the what's his name again? I think he's because Lolly's assistant state prosecutor. I think it's just called the state prosecutor. State prosecutor Mr. Morrissey. The defense wants his emails. So I don't know if that's where they're going to address it here today. Hi, Aleka, how are you doing today? Yes, this is live. Good morning. This is Mr. Hank Brennan. He is new to this case, replacing Mr. Lolly as the lead. But Mr. Lolly is still here.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly,
24-hour period.
Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to the full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She
Wait, did
called
she?
both of them, and those calls were unanswered
Oh,
according to
okay.
the phone records.
I remember that.
The inference that a 40-something-year-old woman is calling her
Can you guys hear okay? Is the audio good? Let me know if you want me to make it louder.
parents at 1:30 in the morning after this tumultuous event. The inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind. The 30-day period is an attempt.
Or she called them and she was really upset with John, and maybe she goes to her parents to confide in them in some of the relationship turmoils. Because it seems like during this time their relationship was starting to get pretty tumultuous. There was like arguments, there was like a lot of back and forth, but then they would make up. They would make up and things would be fine, and they would go to the bar together, and it looks like things were good on the surveillance cameras in the bars. But it could be that maybe.
To protect the privacy rights of William.
But I get what he's saying.
Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there were no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. There
Why not? She deleted them?
were two search
Wait, sorry. I'm pretty sure they did mention that she did call the parents in her original trial.
warrants from Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The two search warrants from Miss Reed's phone are from a period of January 28, 6 p.m. to January 29th at 6 p.m.
Okay.
And the other one is January 28th, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Miss Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now,
Oh, because they were fighting prior. Prior to this, they were fighting. So maybe he's trying to say like, okay, well, let's say Karen Reed says that she called them at 1:30 in the morning a.m. after she's accused of hitting John O'Keefe. Well, you can't say that she was trying to confide with her parents and she goes to them for relationship troubles because they were having relationship troubles before and she didn't call them. Okay, maybe that's what he's getting at.
it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she's panicked calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Ms. Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period.
Okay, so he's trying to be very specific. He's like, I'm not going on a fishing expedition here. I got a theory and I've got a specific timeline of what I want. What is happening? I thought it was a mistrial. Yes, it was a hung jury, and they are trying her again because that's what happened when there's a mistrial. If the jury couldn't, unanimously vote on a verdict or multiple verdicts in this one, there's 3 counts. You get tried again. So the defense has gone to appeal it, and that's kind of like that's kind of happening right now because they don't believe she should be charged with the first-degree murder again. They don't think the state should come after her for first-degree murder. So that's in the appeals right now. They're still making their decision. But right now, we're acting like everything's happening as normal, okay? They're charging her with first-degree murder. They're charging her with manslaughter and then leaving the scene. And the trial is going to happen January. Now, both sides, they want to have it. They want to have it to happen, I think, in April, I said. But it's for the time being, it's slated for January. I don't think Judge Cannoni made the decision yet. Maybe she'll make the decision today.
With William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial. The time of the phone calls.
So the Fox 25, I think that's the one that I did watch. And unfortunately, I hate it when they do those interviews and they just like cut it up and like move all the stuff around. I don't like that. I feel like it's very important to get the context and the timeline of what someone says. So for example, her dad did say that Karen Reed called him, I think, or when they talked to each other. I don't know if it was a phone call or like face to face. And she was like, yeah, I hit something. And so that's like, to us, it's like, oh shit, did she admit to hitting John O'Keefe? And then later on, he follows up with like, oh, she must hit John O'Keefe's car. And I'm like, okay, well, I need to listen to the entirety of his statement. Like, how did he say it? Did he say this first? Did he say that first? What was the conversation about? Like, I don't know. They had it all chopped up, and I didn't like that. But I do remember that interview.
To Ms. Reed are important. They reflect in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts.
I'm sorry, you're right, clever girl. Did I say first degree? I meant second degree murder. So charge 1 is second degree murder, charge 2 is a manslaughter, and then charge 3 was leaving the crime scene. Leaving a scene resulting in death. Thank you. Thanks for the correction.
That she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely.
Now, if you guys don't remember, the reason why she was at the hospital, so upon discovering her dead boyfriend's body in the snow, she and the other woman that was on the scene, oh God, I forgot her name too. So there was Jen McCabe, there was Karen Reed, and there was the other friend. She was more of a friend with John O'Keefe, knew Karen Reed, of course, because that's John O'Keefe's girlfriend. They were all 3 driving together trying to find John O'Keefe because Karen Reed said that she woke up, she was in a panic, that John O'Keefe wasn't home, and went to get Jen McCabe, and then the other third person joined. Fuck, I forgot her name. If you guys remember her name, please let me know because I'm sorry, it's been a while. And so Karen Reed goes home with the friend, and they're driving back. And I think Karen Reed called her dad, and she was like really hysterical. And the dad was like really worried about her, like super worried. I think the dad contacted law enforcement, and then they decided to hospitalize her because, you know, she was saying things about harming herself. So they hospitalized her. She was forced to be hospitalized, and they bring her to the same hospital that John O'Keefe was at, actually. And that's probably when the parents showed up at the hospital. It was like, oh, what happened? You know, are you okay? Like, what's going on?
I just on Miss Reed's phone for a couple of reasons. Number one,
That's why she was at the hospital.
Often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Miss Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Miss Reed's records. The idea of sending it to a taint
I think he said tank team. That's a cool team to be on. Hey, y'all, I'm on the tank team.
I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting of her records, and so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor.
Elizabeth Little.
Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not 1, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy, so the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is, that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't prohibit the Commonwealth from calling him?
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's, and he wasn't present at the Waterfall. Court has repeatedly...
Sorry, just a reminder, McCarthy, Waterfall, those are the 2 bars that Karen Reed, John O'Keefe, and a bunch of friends went to before allegedly everything went down. And 34 Fairview is where John's body was found, and 34 Fairview is the residence of the Albert family, and they were the ones that were at the bars as well. And it's a whole mess. There's a lot of people involved in this.
Emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was 1 call to her father on the morning of January 29th.
Oh,
that was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all 4 elements of Lampron were met. Here, the Commonwealth has failed to meet its burden, to meet even a single prong of that 4-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion.
The Chevy Traverse is John O'Keefe's car. So the crux of the state's case is that Karen Reed has a cracked taillight. John O'Keefe was probably hit by a car. He's got these scratches on his arms, and they're saying that those are from the fragment of the taillights. Okay. Now, Karen Reed and her defense team said that, well, actually, that broken taillight was actually from her backing out of her garage. And in the video, you could see that, like, John O'Keefe's car was tapped, like it jiggles a little bit. So that's I guess that was a Chevy Traverse.
Itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed calls her father cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial.
Now, I think the annoying thing about this judge, I don't think she typically makes her ruling on camera. I feel like a lot of the time she's like, okay, well, I'm going to decide and I'll let you guys know. And then we get like a written ruling instead. But that would be nice if she makes her ruling today.
And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m., after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
Okay.
Is accusation of bad faith. What the attorney says that is most telling is they don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent that trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information that the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of the request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of land crime. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Land crime is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay, thank you. All right, so we will move along now. Both of those are under advisement. We'll move along now to it's paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and or Metro Corp. I do have an opposition that I received this morning in an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So, Jim, did he file an appearance too?
He has previously filed.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
I think it's one of the interviews that Karen Reed did. I don't know if this is the one that was recorded for TV or if it was just like maybe like a print interview.
The Commonwealth has filed a motion to reconsider in part, and in addition, there was a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit
Boston Magazine, okay.
of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, Vanity Fair. And after review of all those materials, it is clear that there are significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were 2 different interviews that were turned over. One was represented at the last hearing that was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing
4 hours long? Where can I find this 4-hour long interview? I want to listen to 4 hours long. That's a lot. That's a lot of talking to do. Oh my goodness. So we got a magazine, we got an interview that's 4 hours long. So I mentioned in the beginning of this video, when we're looking up Rule 17, typically for Rule 17, like it's like on the defense's side, right? They want to get discovery that's not in the possession of the state. So there's a Rule 17 discovery where they try to get like the companies, whatever, compel them to give the evidence over. But in this instance, it's actually the state. The state wants to wants evidence, right? The defense doesn't have it. However, who has it? It is these third parties. So the ones that these companies that did the interviews with Karen Reed, or these companies that have like the cell phone records of her parents. I think for her parents, though, they said they didn't want. They said they didn't. They don't want the physical phone. They don't want the extraction. They just want the subscriber information and I wrote call received. Is that what I meant to say? I don't know. So that's what we're working with right now. These are evidence that the other side doesn't have, but they're evidence at like another company. Oh, hello, start, please.
not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions. They were significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of the defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected. None of that is protected. The defendant enjoys many privileges. But when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team.
And because these are Karen Reed's statements, they're an exception to the hearsay. So these are admissions by a party opponent, which is Karen Reed. So that's why, you know, any thing that she said to like other people, that's why they're allowed to bring it in as evidence.
That privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss, I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And, you know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none.
I was just going to ask about that. I was like, I guess there's no attorney-client privilege because there's a third-party person there, which would be Gretchen Ross, who was doing the interview.
Arguably, all 3 of the attorneys are witnesses as well. Now, the Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them, in the most respectful way to pursue those. The strongest way, the fairest way to pursue those, with moderation, is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on 2 propositions. Number 1, Commonwealth versus Doe, promulgation. Those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it. She said it. There's a difference, and Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that may not be used at trial anyways because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so, since it is not a confidential informant, it's a very public, identified person, it's Ms. Reed herself, the argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I've never seen anything like this, where witnesses have to fear walking out
Oh,
of
hello?
their car.
Oh, we're caught up. I think that's why.
Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I've never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness of the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in a case. And my empathy is to Ms. Voss, but to every other witness in this case. She's in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis in this case. It just doesn't. And so there is a ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them. The Commonwealth is entitled to it, and we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. And the email or text message and phone call, again, statements to the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no exception for it. Thank you.
All right, thank you. Mr. Birch.
Oh, Mr. Birch. I wasn't sure what his name was.
Thank you, Your Honor. Robert Birch for Metro Court and Gretchen Voss.
Mr. Birch with
I've
Metro
been here
Court.
before, Your Honor, on a remarkably similar motion. And Your Honor at that time made a Solomonic decision and said that 2 audio tapes minus
I don't know what's going on with the footage here. It's like stuck.
attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced.
At least we can hear.
And the Commonwealth has simply made no persuasive showing as to why the decision should be any different now. The Commonwealth makes much of the fact that there are heavy redactions on the shorter of the 2 taped interviews. They refer to it as a 2-hour interview. Actually, it was a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating. But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them, though? Didn't I leave that open for them to come back, even at the first trial, to come back and request it upon review of the first release?
I'm sorry, I didn't quite.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first and what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
Okay. Go ahead.
The change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial. And one has to wonder whether this motion is really an effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article, and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment and endangering the safety of herself and her family. And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case, and her fears for her own safety and that of her family are no doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information.
Is there a link to this magazine and video interview that Karen Reed did with Gretchen Ross? Or do I have to purchase the magazine? What about the 4-hour interview? Where's that at? Anyone know? Is that anywhere? Can you guys link it to me in the Discord?
Is more than speculative or theoretical. You said it was a close call, but given making the division, what I call the Telematic division of providing some and limiting others, seemed to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metro Corkins Council undertook at time and expense to redact them to accord with what the subpoena as approved, what the subpoena as issued had asked for. They're asking now for the handwritten notes of Ms. Voss, the one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape. They are partial notes. They are they're phrases. They're not complete thoughts. They're more jog memory sorts of telegraphic mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her, what she takes from the interview, if forced to produce that, it's very likely the next step is that the Commonwealth is going to want to depose her or call her a trial. in order to explain those notes and interpret them. And that's going to take us down yet one more rabbit hole in this case. I've just already had so many. It would also have the effect, maybe the calculated effect, of preventing Ms. Voss from covering the trial, because if she is called as a witness, she is not permitted to sit in the courtroom for the proceedings.
So she did attend the last trial, right?
She did, because
on a
she
daily
was not
basis.
a witness list.
Right, on a daily basis?
I believe so, yes.
Okay.
Every day? Yes.
Okay, thank you. And that was Ms. Voss who just responded to you?
I'm sorry.
That was Ms. Voss who just responded to you, yes, correct?
Yes.
Okay, thank you.
And finally,
Oh, is she in the courtroom back there?
the Commonwealth asks for the first time, for texts between Ms. Reed and Ms. Voss. And we do have texts. They are, the manner in which they get forwarded from an iPhone is that they come out without the name of the speaker. You can sort of guess at the name of the speaker, but you don't see the name of the speaker. You also don't see the date and time of the communication. I'd ask that we're willing to turn those over. They were not off the record. But I ask that we be able to turn them over in that form, which is the form we have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay,
Hey, Joe.
And that's all I have, Your Honor.
all right. Thank you very much. Mr. Brennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition. If you've got the opposition with you, Mr. Brennan?
I have a copy here.
Okay. So what I'm going to ask you to respond to is on page 5. First full paragraph. The paragraph begins that this litigation, but the sentence is, in other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you.
Ooh, the sun is coming out. Sun is coming out. So I'm assuming Lolly doesn't make any arguments? Lolly just assists? Now, do you think they're going to split the witnesses between Mr. Lolly and Mr. Brennan, or just have Mr. Brennan do everything? Because I think what happened was at the last trial, Mr. Lolly did like almost everything. He had assistants there to help him, but he was doing...
This posits two separate ideas, the way I interpret it. The first is
He was doing the direct examination, the cross-examination. It was just too much work, and there's so many witnesses. So I hope they have another attorney they can divide it with.
the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided thus far contains many damaging admissions to Reed. In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews the story changes. But at one point she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The stories and the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so all I can simply say is that is not the Commonwealth's position. That is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to...
Who is that speaking now? State or defense? This is the state. The new lead attorney. Lally is no longer lead attorney, but Mr. Lally is still on the case. This is Hank Brennan.
all the other statements she made, 2020, Vanity Fair, Dateline, and others. And so the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions. Also internally, in Ms. Voss's interview, as I mentioned, there are statements, redaction, a return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further drinking. And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water. And so I think that the claim in this motion really has no relevance to the analysis. It's not on point. The reason I said there was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3.
Because 1-hour interview, and I think he said that he only got like 20 minutes of it.
Redacted. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to the 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some. We don't have to take a fraction. Just because it's inconvenient or uncomfortable for parties, the government is entitled to the full force of their proof. In representing the people of this Commonwealth, I am pursuing the full force of our proof in every aspect because we're entitled to it.
Ooh, it is bright in here. Hold on, let me close. That is hard. Okay, all right.
It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the third interview they discussed, and the parties, meaning the defense attorneys, the defendant, the defense attorney, the defendant, and Ms. Voss could decide to use that material. It wasn't that it was precluded or no one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and we're going to pursue it. We're entitled to all of these records, all this information. There is no legal argument against it, none.
All right. Thank you. So I know, Ms. Little, I asked if you wanted to say anything. I just give you that opportunity. Was there anything you wanted to add? No, Your Honor. Okay. All right, so that is taken under advisement. And now we have 3 more motions. I understand Mr. Albano is here, who will be filing an appearance on all 3 or arguing all 3. But so, Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get an opposition this morning that goes to service, which pertains to all three, but do you have different arguments, a little bit different on each?
I do.
Okay, so Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the three? There are three motions, FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10 Boston. Okay, thank you. And again, on these, Ms. Little, you don't expect to argue? No, Your Honor. Okay. If you do change your mind, just stand up and let me know. No, that's fine. Okay. All right, I will hear you. Why don't we start with the FXT TV, Boston 25, it's paper number 400.
As has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I've quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean, right? This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at the phone records that are available for Karen Reed and seeing there was a phone conversation that morning to William Reed's phone. That phone conversation is before Karen Reed is admitted to the hospital. And so it is, by inference, in the back of a police car at the scene. Now, there's some ambiguity during your first discussions. The operative word, as I see it, is first. It is a particularly remarkable statement to make that in the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit supposedly now another car in a driveway hours earlier would be the topic of conversation at that point. There is not a fair inference that that would be the subject matter. It is not a fair conclusion that a person would be so fixated on a mere nudging of another car that caused no damage hours earlier when we're dealing with the potential loss of life. And so I think it is reasonable to infer that that was actually not the complete statement. The conversation lasted on that morning for over a minute, and there was certainly conversations after. And so the defendant's father has, as he's entitled to, utilized media to try to sell a story to help his daughter. And during that airing, it is clear and obvious that not the entire conversation with William Reed has been provided. During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all the statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context. Some of the doctrine of completeness. We should know what the entirety of the conversation, the interview was, so that we can assess this statement and draw the proper inferences from it. It is expected that William Reed very likely will be a witness at trial. He will be asked about this conversation. He may be asked about what else he had said. It will be impossible at trial then to try to produce the other statements that he has made to this network or this employee. And so the Commonwealth, or anybody who would be questioning him, would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he is cross-examined, if there is evidence of impeachment or corroboration that both sides are aware and know of the substance of that material. And that is the reason we request the pleading in number 400 for the Fox 25 footage that was not aired.
Okay. Have you had a chance to read Mr. Albano's opposition this morning? It's not very long.
I haven't, but I can say Mr. Albano kindly called me. He outlined the issues in an email. He made this a much more streamlined and agreeable process. And so I credit him with his effort. I don't need to read his response. I'll appreciate what he says.
Okay.
My short interaction with him, his total candor, I have no hesitation what he says in his representations. I might disagree, but I don't need to read his pleading.
Okay.
There are two, NBC and ABC. If Your Honor would allow me to start with NBC, because I think we can streamline that. NBC 10 has agreed to give promo materials in their possession. I've not only spoke to Mr. Albano, but I've spoke to the attorney for the subsidiaries that we also had subpoenaed. And they told me that as subsidiaries, they do not have possession of the materials of the parent company. And I received letters from the attorneys stating as much. So as it pertains to NBC 10, the position is that one of the subsidiaries is going to send us promotional materials. And as far as service on the parent company, I don't think the Commonwealth succeeded, despite the fact that we made numerous efforts in hand, mail, UPS to a number of subsidiaries. I don't think we're satisfied, so I do not want to ask the court to progress that.
Okay. Do you have a timeline on when you'll get this material?
The promotional materials?
Yes.
They said they were putting them together. I did not ask for a timeline.
Okay.
The promotional materials are a very small fragment. It's, I've only seen one clip aired. I don't know what else they have, but it should not take them long.
Okay. I don't have a paper number. Jim, do you have the paper number on NBC 10? Here, just, you know what, Jim, you can give it to me after. I don't have that paper number or the other one. All right, so do you want to...
427, Your Honor.
What is 427? 427, yes. All right, so do you want to move on to CBB TV?
Yes.
Okay.
WCVB-TV has been served, and they've notified that they're not in possession of the materials, have no control over the parent company, and they are not part of the company. And so I no longer am asking WCVB-TV to produce these materials. Instead, in the alternative, we have subpoenaed the registered agent in Massachusetts, the registered agent for the parent company. They have been properly served. If we look at the Secretary of Commonwealth of Massachusetts Business Entity Summary website, not only do they have a principal place of business in New York, but they also have, as a registered agent, a local address, 84 State Street. So our position relative to the ABC materials is that ABC has been properly served locally. Unlike NBC, that did not have a local registered agent that we could find, or perhaps does not have one, ABC does. ABC does business in Massachusetts. In fact, these interviews with Ms. Reed may have taken place in Massachusetts. I don't know. But they have roots in Massachusetts in that they do business here. They have a local registered agent. And the reason to have a registered agent is to accept service, provide notice in case there's objections, and to provide materials. It is done routinely in civil cases when a registered agent is notified. They are then obligated to get materials even if the REM exists in a different place. Their position is that the REM exists in New York. That is irrelevant to the assessment in this case. To suggest that somehow the physical property being another jurisdiction is not in the control or purview of the local registered agent would just be enacting a shell game where local or companies could pick jurisdictions they find most favorable, do business in outside jurisdictions, and avoid the consequences of that. That I don't believe is how the law is set up. As a registered agent, they are the same as the company. They just have a local contact to
Oh, was I muted? Oh no! Okay, I was just responding to thank you, Vibrant. I was responding to Moondog. Sorry, I haven't muted just in case because I have stuff happening in the background. I didn't want it to be super loud, but I think it's quiet back there. I guess I will mute it when it gets loud again. So Moondog says seems as if both sides are unsure what happened. No, both sides are very certain. So the defense, they said that Karen Reed had nothing to do with it, that she backed up into John O'Keefe's car. That's how she got the busted taillight, and that maybe people should be looking at the McCabe's and the Albert family, and were there any other families? I think just those two. As for the state says no, Karen Reed backed into John O'Keefe with her car, and that's why she has a busted taillight.
accept all types of service, communications, and responsibility. And so our position on ABC as far as service is concerned is they've been served through the registered agent, and therefore whatever materials exist, regardless if they're in Massachusetts or in New York, they are required to obtain them and they're required to produce them.
Okay, so Mr. Albano disagrees with you, and on the third page of his memo under paragraph 5, so I will give you the opportunity to read that.
Okay.
Under that 5th paragraph. Do you want to address the substance of your motion regarding ABC?
I do. Much like other recorded statements, we see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made to a national audience that don't reconcile with other statements she has made at other times. I've given you the example of not knowing which door she supposedly saw John Keefe go into. There is...
Okay, so WCTV is part of ABC. That's why they're not going after WCV anymore. They're just going to ABC directly because ABC has a local registration with Massachusetts. Now, who the hell was CBB-TV? I missed that one. Did I get the acronym wrong?
Much like other recorded statements.
Sorry, I'm just rewinding it back a little bit.
Albano disagrees with you, and on the third page that,
Okay.
under that 5th paragraph, do you want to address the substance of your motion regarding ABC?
I do. Much like other recorded statements, we see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made to a national audience that don't reconcile with other statements she has made at other times. I've given you the example of not knowing which door she supposedly saw John Keefe go into. There is differences in her stories and versions about where she was that night after she left the O'Keefe house. There is a number of examples where the different versions given contradict each other. And so although they're all substantive statements, they're all admissions and confessions, they still have a value in the fact that they contradict each other. And so the episode that is aired, 2020 Nightline, you hear oftentimes the author of the story, not even the interview, the author saying, and we spoke to the person, and then this is what happened, and then they go to a clip of an actual interview. The summary by the author is not admissible. It can't be used substantively. It can't be used to impeach Ms. Reed should she testify. It is hearsay. It's inadmissible. And so these summaries have a genesis somewhere. There's a reason why the reporter is asking certain questions, or more importantly, the author is summarizing testimony, oftentimes inconsistent with other versions.
It's nice to see the new prosecutor appears to be on top of this game and communicate clearly. Yes, he is just like on point, just straight to it, no bullshit. I like it. Now, we'll see how he performs in trial, though, because maybe he does better in pretrial stuff. Because when I was reading some of the motions that Lolly wrote for pretrial, I'm like, oh, this seems pretty decent. But then we saw Lolly in action in the trial. I was like, ugh. So we'll see, how he handles the witnesses, how he does direct examination, cross-examination.
And so that means that there is footage from which the author has gleaned this information. There's either footage or there's a conversation with Ms. Reed. And so those are statements, not similar to or dissimilar to Ms. Voss interviewing here. Those are statements of a defendant, which are substantive evidence for their full value. And so that footage we're entitled to see. There's nothing that should protect it. We should have the opportunity to review all of the statements and also put the ones in context that were broadcast to the nation. And that's the substance of why we want it. I'll have to take a moment to look at the response.
Okay. Mr. Albano, we'll give him a couple of minutes just to read it. Sure.
All right, he's going to read it.
Read. The pages aren't numbered. Have a seat and read it.
There's Mr. Lally, though, if y'all missed him. Hi, Mr. Lally. I wonder if they're gonna split the witnesses between. Karen Reed's dead. I wonder if they're gonna split the witnesses between Mr. Lally and Mr. Brennan. Yeah, whoever's holding the camera, they love doing the zoom ins.
Sure.
Thank you. Your Honor, our position is we disagree with that proposition. We are not trying to subpoena another state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, by having a registered agent, we believe that gives us jurisdiction. I can understand the company would like to remove this to New York. There is a reporter's privilege in New York that is profound. It is not so in Massachusetts. In Massachusetts, there is none. And so I see why it is the company's preference for us to go to New York, to use New York law, but I don't believe that's the case. I believe as a registered agent that we have an entitlement to subpoena them here, and we follow Massachusetts law. There are a couple of cases in the memorandum that I'm not aware of. I think it would be prudent for me to research and jeopardize, and because I think I have an obligation to do that. I would ask you to allow me to have a day to provide a brief supplement. It's not to re-argue the case or the merits of the case, but if there is adverse case law, I want to recognize and acknowledge it. But not,
I'll give you that opportunity, but I will hear from Mr. Albano today since he's here.
of course. But our position is, although they would like us to go to New York, we can subpoena in Massachusetts to the registered agent, and that entitles us to the material, so that's the way we've done it.
Okay.
Thank you.
All right, Mr. Albano.
Mr. Albino.
Thank you, Your Honor. The two cases I cited, just to be clear, they address the Uniform Act, which Your Honor dealt with last year. They don't address the specific issue that Commonwealth has raised, which is, okay, you have a registered agent, we serve the registered agent, does that trump the Uniform Act? I have to say, I did not find a case that dealt directly or even indirectly with that. But here's why I believe the service issue does not override the Uniform Act. First of all, we're dealing with a statute. Statute talks about a witness in another state. There's no dispute that ABC is a foreign corporation with a principal place of business in New York. Now, the analogous areas I thought of was, okay, let's say someone wanted to sue ABC in this court. Yes, they could serve them.
Hello? Is it just me? What happened? Come on. Okay. It's not just me. Frozen? All right, we'll wait. We will wait. I don't know. My thought is if you are accused of a crime and you got a trial happening up,
Case.
I would say don't do interviews. Don't do interviews. You never know what they might use against you.
Just generally explains how this Uniform Act works. You go to the Superior Court here.
Hi, Fire.
You get an order. You travel to New York, and New York decides whether the subpoena will issue. The second case, which I think was in re contempt or something like that, was the SJC saying, by the way, the receiving court, and in that case, Massachusetts was the receiving court, we don't just rubber stamp these if there's a privilege issue in our state. And so that's what tells us that if this court issues an order under the Uniform Act, Commonwealth travels to New York, the New York court then decides, does it enforce it, or does the privilege that exists in New York, is that privilege dispositive? And that's what we say is the right answer here, that, yeah, they have a point, they can make service, but it doesn't override the statutory requirements of the Uniform Act. And as to the other, I think things are pretty much under control with the other motions. WBTS, which is NBC 10, has previously published those promotion ads for the show, and they say, well, no, they've already been out, fine, we'll get you copies, and that's what I've been told by the client as well. WFXT, which unlike ABC is here,
Right.
does have some raw footage. The station's position is that if Your Honor decides under the Rule 17 standard that yes, this footage is relevant enough to come within the Rule 17 scope, then WFXT will produce that information. I do expect it will already be published before, so the unpublished I do expect won't be unpublished anymore, so they'll probably be in a position where they're simply turning over published information,
Okay.
not unpublished information. But I do think that, so I think WBTS and WFXT are effectively resolved.
Okay. Do you want to respond, Mr. Moran? Thank you, Mr. Albano.
I'd just like to give one example that I'm sure you've thought of, and we see it often in tort law. If U-Haul is a foreign company, I don't know where it's located, but if the principal place of business is in Texas, and there's an accident here in Massachusetts, and I'm requesting as part of my litigation corporate materials, I do not have to follow the Uniform Act to go to Texas or litigate in Texas under Texas law. Because the company operates also.
Who are we zooming in on? Do you guys know? I don't recognize anyone back here.
In Massachusetts, as does ABC. I can sue in Massachusetts, and that company, this registered agent, is obligated to get those materials for me. Otherwise, a company could
Oh, wait. Is she the reporter, maybe?
simply hide in whatever state is most beneficial to them, make it impossible to litigate or obtain materials, and there would be subterfuge throughout the entire process. We have jurisdiction here because they operate here, because they have a registered agent here. It does not matter where their corporate or their headquarters is. Thank you.
All right, any follow-up, Mr. Albano? Sure.
My first point is that we're dealing with a statute here, and the statute says this is how it works when you have an out-of-state witness in a criminal case. So that's different than civil discovery. The second thing I'd say is ABC has a registered agent here, but WCVB is owned and operated by Hearst Corporation. Hearst Corporation is totally separate from ABC. That's why neither of them could produce the documents in this case. So I just want to be clear that the presence of an ABC affiliate here, owned by an entirely separate company, Hearst, does not mean that ABC is here in Massachusetts. They're a foreign company that has an agent for service process. They don't have offices and the like here in Massachusetts. Are they doing business here in the sense of transmitting ABC News programs through affiliates? I don't argue that. What I'm arguing is there's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The SJC has said in the grand jury case, the first case I cited, that the same procedures apply for documents as for witnesses.
Okay.
Thank you.
All right, thank you. So those are all the Rule 17 motions we have. Am I missing anything? Those are all the Rule 17 motions. Right? All right, so we have some housekeeping matters that I just wanted to check on. I still have the motion to continue under advisement. I need to see how we progress for a bit.
She hasn't made a decision on that yet. Both sides want to move it to like April. What's the issue with that? Now, I know the same thing happened in the last trial where both sides wanted to delay the case, the trial, and she denied that. And then look what happened. The trial happened, and it was just messy. It was just messy. I think the state needed way more time.
The Commonwealth's notice regarding the testing of the Telematic system.
Yes, that's the car stuff. Okay, so the first one was motion, continuance, and then testing the Telematic system. So hopefully getting more information from Karen Reed's car. We'll see.
Where do we stand with that, Mr. Brennan? I know you had said you told them that, Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did, and if I could have done it, had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to Texas on December 2nd.
Okay.
On December 2nd, they're going to test all of the chips, and there's an SD card that we expect has information on it. And then they're both scheduled to travel back to Massachusetts for December 5th.
Okay.
And they're going to do what's called a chip-on, where they take the chips, the SD card, they reapply it to the boards, they put it back in the modules, and they put it in the actual card.
Apply to boards and modules. Because here's a recap of the last trial. This is what we found out in the last trial. Oh, in regards to the car. Okay. The information from the Informatics manual and information taken from the Telestream manual had irregularities. The state said that they realized all the data was unreadable. Now, initially, they thought it was not fully downloaded because there's obvious information missing, like the navigation, the phones being plugged in, travel logs. They were all missing, and apparently they filed a supplementary report saying that the chip taken from the Telematic and the infotainment system were read with the wrong reader. And then further, for the infotainment system, apparently there are 3 boards, but only 1 was taken out. So they hired a new expert to take care of this. However, this new expert, the defense was saying, well, this expert doesn't know the difference between a megabit and megabyte. I think the state expert said that they did a sum check. Yeah, you do like a sum check to make sure the data before and then the data afterwards is like the same amount of data, and that you didn't lose any data while doing whatever it is that we're doing. But the defense was saying that, well, the state expert didn't know the difference between a megabit and megabyte, and so the discrepancy of data, maybe there isn't one. So, but now the defense expert and the state experts are going to work together, and then they're going to work on all the information from Karen Reed's car, and we'll see what happens with that.
Because there's different software which will give it even a more fulsome reading. And so after boards, they put it back in the modules and they put it in the actual car, because there's different software which will give it even a more fulsome reading. And so after the December 5th event is done, I've asked my expert if I could have all results within a week. I have an uncertain response, promised to do his best, which really doesn't give a lot of meaning, but my hope is within 7 to 10 days.
Okay, thank you. And I don't know, Ms. Little or Mr. Jackson, if you have the answer to this, the transcripts of the sidebar conferences. Ms. Little, do you have any scheduling idea on when those will be available?
Yes, Your Honor. I do believe that Mr. Jackson had spoken with the court reporter and emailed the clerk's office with an update. It's going to be a little bit longer than initially expected. One of the reporters had sort of like a family emergency and needed some additional time. And so I believe, and I'll have Mr. Jackson correct me if I'm wrong, but I believe she needed until about 6 weeks to get the sidebar conference.
6 weeks from the November 13th date?
6 weeks from about a week after the November 13th date. Thank you, Your Honor.
Thank you. All right. Mr. Jackson, did you want to speak?
Your Honor, Ms. Little addressed the court's specific questions about the transcripts, and that's
Ooh, the audio is so good. Yay! Remember in the Sarah Boone pretrial stuff, whenever they had someone talking on the Zoom call, whatever it was like the audio was so bad. This audio is good. Crisp.
Your Honor, Ms. Little addressed the court's specific questions about the transcripts, and that's as accurate a bit of information as I have, so I'll submit on that.
All right, thank you. All right, that is it for today. The Commonwealth is going to file a response to the discovery of communications in possession, custody, and control of the Commonwealth by 11/27, right?
Yes. Your Honor, I provided the defense this morning with a response to their motion. We'll file it with the court. It is a request that they made that is very labor and time consuming, but a very important task that I've been involved with. I expended many, many hours, and I need many more. We do have, or I have produced, or I have a production that I'd like to produce to the defense. I've shown them a protective order this morning to see if they were agreeable. I do not want to speak for them. If there is a protective order, I can turn over the first production that I produced, and there is more to come.
All right, any objection to the protective order? I have not seen this document, obviously, nor the proposed order.
Right. There are a couple of issues related to this motion, in addition to the protective order, that I'd like to address with the court that I've briefly discussed with Mr. Brennan.
All right, I haven't read this yet, so I won't know what you're talking about, Mr. Kennedy.
So I believe you have read our motion, right? The motion that
I read your motion, I haven't.
Right. So it's just in relation to the
Oh man, this is so like trial stuff right here. Lots of back and forth with your daddy and the judge. Ding dong, ding dong, ding dong. Like a little ping pong tournament.
motion, Judge.
All right.
So, Your Honor, generally speaking, we do not have an objection to a protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here, or was there a proposed protective order?
I have it right here, Your Honor. Mr. Brennan provided this to us this morning.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with the
There's no
defense team?
objection to the parties they would like to share it with, and I understand it's without prejudice.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used the personal email address to make an ex parte communication with the court. One concern that we have is that we were told this morning that with regard to Mr. Morrissey's text messages, not emails, but text messages, apparently they're somehow remarkably set to auto-delete after 30 days.
You could do that? What? Set up auto delete? Can you do that? I'm trying to think. Auto delete. Have I ever seen that before? You can? Was it on Android, iPhone? Interesting.
That obviously raises some questions for us. Maybe the subject of a future motion, but more immediately,
What phones do you guys have? You have it on your iPhone? What? Dude, for me, I like to have a record of like everything. But yeah, I need to let go. I need to let go and start deleting things. I don't know, because I feel like you never know when you might need to look back and scroll back, and I don't know, if you need some information or something, I don't know. Attachment to data. I gotta let go.
concern is every day that passes, we're losing text messages from 30 days prior. So, through today, I
Are they
believe...
preserved, Mr. Brennan?
I've been preserving them since I started the task last week. I'll continue to preserve them.
All right, so that...
Yes, that deals with that issue. So the only remaining issue...
Nice, Mr. Brennan. Nice, Mr. Brennan.
Your Honor, is with regard to the searches that Mr. Brennan conducted himself, he had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
Okay. The significance of that is?
The significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort. However, we think we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed, R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name, but we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court, where this case originated, and this court as well. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication, and we'd ask that a more thorough search be done for these types of communications.
All right, so why don't you continue to talk with Mr. Brennan, and we can have a hearing on this motion if there's anything that you still need on December 12th when we're back here for the Daubert hearing.
That's fair enough. Thank you, Your
Does
Honor.
that make sense, Mr. Brennan?
Because I've taken extensive steps to do this myself to accommodate the defense in the most broadest fashion, and I'll continue to do that. If they want to discuss how I can accommodate them, something like that.
Okay. All right. So we will see everyone December 12th. So when do you expect to get me any
I think December 12th is at 9 a.m., which is 6 a.m. my time. Ah! East Coast time.
written material you want me to have prior to the Daubert hearing?
Yeah.
Yes.
Your Honor, we drafted a planning and hearing motion. I need to review it. I'd like to get it to you by the end of the week.
That's great. I expect to be here by at the end of the week, so that's great.
Thank you.
And your response by next week, Mr. Yannetti? Ms. Little?
Yes, if we could.
Sorry, I missed that. I think I was focused on my stomach growling. Hold on, what did he say?
That's great. I expect.
Yeah.
Yes.
Your Honor, we drafted a planning and hearing motion. I need to review it. I'd like to get it to you by the end of the week.
That's great. I expect to be here by at the end of the week, so that's great.
Thank you.
And
And your response by next week, Mr. Yannetti? Ms. Little?
Yes, if we could have it at least a week, Your Honor.
Okay. So I'll give you 10 days,
Thank you.
as long as that gets me before the 12th.
No problem.
All right.
Yes, Your Honor.
Yeah, if I can get it, as soon as you can get it. All right. Anything else? Yes.
I'm sorry to interrupt.
That's okay.
May I inquire if the protective order is going to be signed by the defense?
Are you going to sign the protective order, Mr. Yannetti?
I expect I will, without prejudice.
I have the material. I'll just wait. to make a
Okay.
decision.
All right. So if you sign it, then I'll endorse it, Mr. Yannetti. You had it, right? Ms. Little gave it to us just
I
now?
believe we just gave our copy to the court.
Yes.
All right. So this is the one that needs to be signed, and I'll endorse it. Do you want to take a look at it?
Yes.
Oh god, that is a fast camera swing. Getting a little bit of motion sickness.
Yes, Your Honor.
You sign that, and I will endorse it.
Thank you.
Okay. Anything else?
No, thank you, Your Honor.
No, thank you, Your Honor.
All right. Thank you, and I appreciate counsel and the third-party record holders coming in today.
12:9 a.m. All rise for the court, please.
9 a.m. Oh man, who's sticking to 9 a.m.?
You are muted.
Hi, lady. Good morning.
Goodbye.
How you been? Not good. I have not been taking care of myself. My back issues and my neck issues have flared up because of bad posture. I got sucked into this other trial that was happening that wasn't being televised. And then I was catching up with 2 other cases. Well, actually, 3 cases, including this one. Just really bad posture. Yeah, not good. Thanks, Bogart. Because typically when I cover cases, I have to make sure that like my body's in good health. Otherwise, like the Sarah Boone trial, I think I did pretty decent. But by day 7, I think my body was like hurting. Like I couldn't even sit in the chair. It was like really hard. I had to like get up often and like take Advil and stuff. Ah! All right, we'll do a little mini recap. But I was just trying to catch up with all the cases, but I got sucked into the Delphi case. Oh my God, the Delphi case. That's a wild one. Yeah, the issue is that I get really, I don't know what's the right term. Not like obsessed, but I get really focused onto something and it makes me not want to get up. It makes me not want to drink water. It makes me not want to like take a break and eat. I have to like force myself to do all that. Let me take off the sound fixer. Audio boosted? Yeah, so what happens is I get really like sucked into something and all I want to do is just work on it. Like I want to do all the research, you know, do all my notes and stuff like that. I just have to remind myself, okay, I got to get up and stretch. I got to change my posture. I got to take a break from the screen because like my eyes will start getting strained. Laser focus going, yay! Yeah, when the Sarah Boone trial, I didn't even work out, which is not good. Because I usually have to be like active and like, you know, move my muscles around and all that stuff. But yeah, it was not good. Not good. It was like the Sarah Boone trial and then I got sucked into the Delphi stuff. Not good. But yeah, Delphi stuff is very, very, very interesting. But Tam, I hope you've been well. How are you? Oh, also, y'all, I went back to iPhone. I was on Android for a little bit. I'm back to iPhone. Oh my God, iPhone is so flawless. The unlock, the face detection feature is so quick. I don't have to deal with the Android thumbnail not registering my fingers anymore. And things are just so smooth. I don't know. I'm glad that I'm back to iPhone, I guess. All right, well, that was it for the Karen Reed hearing. Oh my God, my stomach was growling. I need to eat. 4-letter words, insert here. LOL, Corgi. What does it begin with? Ooh. But yeah, the issue is just that I just have to change my posture. I got to take a break from the screen and I got to not be so obsessed into something. All right. So for today, what do we cover today? I got my notes here. I think it's easier for me to take notes using pen and paper because sometimes you can go back and circle stuff. I don't know. For some reason, when I type it all out, it just looks like letters to me. When I review it, I'm just like, oh, God. So I'm going to experiment to see if I should do handwritten notes or typing. Maybe mix of both. We'll see. I went back to iPhone. It's so nice. It's so nice. The reason why I really like iPhone is because I mean, everyone that I know has like an iPhone and then, you know, you the Find Friends thing. So if I lose my phone, if I'm like hanging out with friends, my phone gets stolen, they can use the Find Friends to track me. The other way of tracking me was using like an Apple AirTag that I had to attach to my Android phone. And that shit would just pop off, you know, it's kind of annoying. It's like having a giant pimple in the back of your phone. Or the other method, which I didn't like, was using Google to track my location. But I don't know. I didn't like that. I thought it was like, I don't know. Because if you pull up the Google map, then you can see like the location of like where I am and stuff like that. I'm like, I don't know if I like that. So we're back with iPhone. Although I think the issue with iPhone is that people just love stealing them. You know, I think iPhones are probably like, well, their value a little bit better. Because when I had Android, I'm like, no one's going to steal this piece of shit. It's a piece of shit phone. No one really cares about Android. But with iPhones, dude, all my friends that have iPhones, they've always been targeted and had their iPhone stolen. Like in your hand, if you're at a concert, they'll bum rush you, they'll take your phone. But yeah, I don't know. Just be careful. Be careful. All right. So for today was mainly the focus of the Rule 17 discovery. So this is the state. They want evidence not in the possession of defense. This is evidence that's in the possession of like these third-party companies. These third-party companies include, you guys probably can't read this, but I'll read it for you guys. So for example, we got audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss and Metro Corp. Gretchen Voss did an interview.
A person commits conspiracy to commit murder.
What the fuck is that noise?
Person...
Oh, what the hell's going on here? What is this? Day 167. Oh my God. The YSL stuff is crazy. All right. I was like, what is that noise coming from? Of Gretchen Voss. Oh, it's Gretchen Voss. That's why I wasn't able to look her up. I was looking up Gretchen Ross and I kept getting Gretchen Rossi, who used to be a housewife. So we have a Gretchen Voss who was on, this is with Boston Mag, I think. And so they want all that evidence. And again, the defense is in possession of that. And in order for the state to request those, we have to have a hearing about it with the judge. And the judge didn't make her decision yet. So we have that with Gretchen Voss. We also have video recordings, audio recordings, interview notes, emails, text messages, and voicemails of Karen Read in the possession of Universal Television, NBC Boston 10. NBC Boston 10, are they with ABC or is that the other company? And then we got video recordings, audio recordings, interview notes, emails, text messages, and voice messages of Karen Read in the possession of Universal Television, NBC 10 Boston. Oh, sorry, that was the same thing. NBC 10 Boston. We got video recordings, audio recordings, interview notes, emails, text messages, voice messages of Karen Read in the possession of WCVB TV, part of Hearst Television Incorporate and ABC. But I think they said Hearst Television was separate from, they're their own company, even though they're like affiliate with ABC, but they're their own company. And what else was there? I think that's it for the news companies. Now, in addition to that, the state also wants to have the phone call records of Karen Read's father and mother as well. Where was that? That's somewhere up here. William Read. William. Is it spelled William the normal way? Yeah, William Read and Verizon. And then same thing with, I think, Janet Read. Records from Verizon Wireless, Janet Read. So again, Verizon Wireless has all this, but the defense was like, well, they have Karen Read's phone. They got Karen Read's Verizon. They can just get the data from there or the information from there. But the state was like, no, we can't. So they want to do the call logs. Let's see. What do I have? Call subscription information and call records. So they're trying to say that, well, you know, Karen Read tried to call her parents at 1:30 a.m. that morning after allegedly hitting John O'Keefe. And why would she try to call them? The call was unanswered, though. The state wants to show that within the past 30 days that Karen Read has not called her parents. So something extraordinary must have happened around this 1:30 time frame. And that's the reason why she called them. And at some point when Karen Read did speak with her father, apparently there was an interview that Karen Read did. So it's all kind of like mixed together, these like phone calls and like the interviews. But apparently when Karen Read was on, the father was on Fox 25. The father said that Karen Read said that she hit something at the hospital. And that he was trying to say that like the state was saying, well, if Karen Read was trying to call her parents at 1:30, then she must have knew that she hit John O'Keefe, and that if she had done something within the 1 to 2 hours, maybe she could have saved John O'Keefe. So I think they're trying to, prove this inference that, okay, well, we need to get the call records to prove that maybe Karen Read knew she hit John O'Keefe, and that's why she later on made that statement to her father about hitting something. But with the Fox 25, this is the one I watched. We only got like bits and pieces of it, and we don't know if the context is all like screwed up. Because we got pieces of like the statements the father made and then like a copy pasted statement from like, I don't know, like maybe later on or maybe before. So I don't know. That's what I don't like about those interviews. I feel like we need to get like the full interview, no edits, just get the full interview. But I felt like it was so edited that you didn't know if the context, if you could really trust it or not. You would have to really trust editing. But that's essentially what happened today. All these interviews that Karen Reed did, the phone call records. And then we'll be back on December 12th. December 12th for the Daubert hearing. Daubert hearing. If expert's testimony is admissible, parties will examine challenge expert in open court to develop their testimony for the purpose of evaluating its admissibility. I think this is for the crash reconstructionist expert, maybe. If the state has hired a new crash reconstruction expert, goodbye, Trooper Paul. Trooper Paul was the previous crash reconstructionist expert, and I mean, I just don't think that he was qualified for the testimony that they expected out of him, you know? And it kind of sucks because he did the training with the state, and maybe they expected, you know, I don't know. It kind of sucks. This training was given by the state, and when he went up there and testified, it just really, it lacked that like satisfying expertise that you usually hear with someone testifying in the stand. It was just like, oh, okay, like this testimony was it was all right. It wasn't, I don't know. I don't want to even categorize it all right. It was just like very lackluster. And then maybe, let's see, I think it's for the crash reconstructionist expert. But right now, the two experts from the state and defense, they're going to work on Karen Reed's telematic. So the stuff on Karen Reed's car. Remember what we heard from the state? They're like, oh yeah, Karen Reed was backing up, what was it, like 40 feet at, what was it again? Or was it 200 feet? Was it 200 feet at 39 miles per hour? I don't remember. But apparently they got that information. So we'll see if we'll hear the same thing echoed in the new trial. But the state and the defense, they are going to work together to try to extract information from Karen Reed's car. Seems like they're going to be meeting up on December 20th. I think they said they're going to go to Texas. They're going to work on the getting the chip and the SD card. And then on December 5th, they're going to travel to Massachusetts and do a chip on. Where they're going to get the two boards, they said, from, because I think the boards were probably taken off and probably like kept in evidence. They're going to put it back into the modules, and then they're going to put it back in the car with the new software. So maybe with new software, they can uncover more information. But then again, you know, remember, when you're doing stuff like this, sometimes you run into the risk of destroying data. So hopefully they don't destroy anything. We'll see what happens with that. Let's see. And then they talked about, getting Mr. Morrissey, the state attorney. So Mr. Morrissey, we didn't see him in the trial, but we certainly did see him in the interview after the trial happened. Mr. Morrissey, they're going to try, the defense wants to get his work and personal cell phone. They want to get his text messages. They want to get the emails, basically his communications with, I guess, judges, with clerks, previous judges, previous clerks, pretty much anyone that worked with those judges. And they want to search the term read and perhaps name the witnesses, name the judges. And that's going to be very interesting. I wonder what they're going to uncover. I have someone that does the massages. I don't do Thai massages though, but I have someone that I go for massages like every couple, like, you know, maybe like month and a half. I wish East Coast Court had banker hours at least. Oh, I think they do. Banker hours are like what, 9 to 5? I think they're 9 to 5. Extend my time. Trooper Paul didn't even study physics and car accidents. Are all about understanding the inertia. Basic physics is a must. I hope you feel better soon. Yeah, I remember they asked Trooper Paul for the definition of was it like acceleration, and then I think he kind of like struggled on the stand to answer that, and that's like a very basic physics question. So yeah, that was fun. That was fun. I'm like, should I review my old notes from the original Karen Reed trial? I guess I should. I kind of don't want to because I felt like it was such a headache. I'm just like disappointment after disappointment after disappointment. And then remember when the medical examiner finally testified, and it wasn't even like, if I remember correctly, it wasn't really anything crazy. It was like, okay, all right, well, Mr. Lawley saved the medical examiner for last when the medical examiner should have been one of the first, beginning witnesses. Maybe after like the family witnesses, the friends witnesses. Ugh. All right, but yeah, I look forward to the new trial. Again, we're waiting on Judge Canoni's ruling on whether or not she's going to allow for the for them to continue for the continuance. So instead of having the January, was it January 27th? I think January 27th is like 2 months from now. Instead of doing it in 2 months, you know, give them like, I would say give them a couple extra months, you know, to make sure they have a good solid case, and that way when they're doing the trial, it's not going to be a hot mess, because it was a hot mess on this. I don't know, like when the state was doing their stuff, it was just a hot mess. I think it's because they were just not prepared. You know, they asked for a continuance. Defense also asked for a continuance, and the judge was like, no. I think during that time was when the federal investigation, like a lot of the stuff, information came out of that, and I just don't think the state really had much time to work with it. I don't know. It just felt so disorganized, and I'm like, Judge Canoni, don't you want like an organized trial? Don't you just want a good organized trial? That'd be great. That'd be great. 10 to 5. I don't think those are banker hours. I think bankers, isn't it like 8 to 5 or something like that? All right, y'all. Well, I'm glad that the hearing is over. I'm gonna go eat. It is 9 a.m. I appreciate y'all being here, and I think there was something. Oh, actually, I kind of want to watch, because I think I did want to watch the Lori trial. I don't know. Should we do that a different day? Maybe we'll just get to where I want to go to. Hold on. What is he doing? Hey, excuse me. Are you going through my? Oh my God, he's going through my purse. Excuse me. Hey, nope. Shiro, nothing in here. I already gave you all the snacks. No, Shiro. Oh my goodness. This giant ass corgi. I had snacks in there, so I think he was he could smell it. He was like, "Oh, the snacky's still here." This guy stealing my stuff. I just want to watch this briefly. Just briefly. This won't be long.
All right, I set the status conference.
Lori Vallow. So Lori Vallow is now in a different state. I think in Arizona. Yeah, she's in Arizona right now. In Arizona for accused of murdering her ex-husband and accused of plotting to murder her niece's ex-husband as well, Brennan Bordeaux. Apparently she speaks because she wanted to represent herself. I'm like, oh God, please no.
Determined to be incompetent at any point?
Not to my understanding. So my understanding was that the judge did the same thing that you did, in abundance of caution. Let's go ahead and put her in and see, and I came out competent.
Well, when you say you came out competent, was there a period of time where you were ruled as incompetent?
I would say technically they did do that. That's how they put you into the program in that state. Correct.
How long were you in that program?
I was in that program for about 10 months.
Okay. And what types of things did they give you classes? What types of things did they speak to you about where you went through some process where you were later deemed competent?
I did go through a process of several things, several classes, competency class, and meeting with doctors and evaluators, many evaluators.
Are you aware of any diagnosis that you were given?
Yes.
And what is that?
What?
It's like we don't have the right camera, so let's zoom in onto this camera. So we have to look at the back of her head. Damn! How did she get her hair did? She got her hair did. She got her makeup on. How did she get access to this? Poor Sarah Boo didn't have access to this.
We're going to object to that, especially with this being public and not sealed.
It's not relevant to this determination.
Okay, well then.
This was almost 2 years ago.
Then I'm going to keep her in the Rule 11 process to determine that. And
approach and discuss with
Sarah Boo couldn't even get eyeliner. Then she got her own like eyeshadow. She got her hair all crimped, or maybe she naturally has like this curly hair. I don't know. She got a hair tie there.
You without it being on the record.
And remember, she's already been convicted. She's already been convicted. Sarah Boo wasn't even convicted when she requested all those.
Public on the record, but not public.
You mean as far as the diagnosis?
Yes.
Sure.
that part. I don't know how.
I mean, she sounds pretty normal so far. Oh god, why are we zooming on the feet? Y'all, she wearing orange today. Orange creamsicle socks with some orange creamsicle sandals. Caravan is just bored at this point. Let's just zoom in on the fingernails. Alright, they're discussing. They're back. Lori Vallow really likes his hairstyle.
All right. All that was on the record. The court reporter took it down despite the white noise.
But it was sealed for the public.
What was that?
That part was sealed.
I haven't sealed anything yet, but I can.
Did you tell him or you didn't tell him?
I think that was Lori whispering to the microphone. Lori, your microphone's on. What trial is this for? This is Lori Vallow. So she's already been convicted for the murders of her 2 kids and for Chad Daybell's wife, not ex-wife, Chad Daybell's wife, Tammy Daybell. Now we're in a different state. We're in Arizona now because she's accused of plotting with her brother to murder her ex-husband and plotting to murder. I mean, that happened successfully because her husband, her ex-husband's dead. And then plotting to murder her niece's ex-husband, Brennan Bordeaux.
You said it the way you said it. That it was a split decision.
Girl, your microphone is on.
All right. I'm inclined to keep Ms. Vallow in the Rule 11 process based on the prior attorneys. I understand these attorneys today disagree with the prior attorney's assessment. But because of that conflicting viewpoint, I think I need to let the Rule 11 process play out. So do you want to, anything additional you want to put on the record regarding that?
There's a couple of, can I just have a moment to?
Sure.
Yeah, smack that microphone.
Yeah, isn't that when the next?
Does she not know how to mute her microphone? Oh my god, this is painful.
Next year, 11. Yeah, isn't that when the next? I see the thing. You'd all 5 a.m. Okay. 3, 5, whatever. Oh,
I think she didn't know how to mute it, so she smacked the microphone away, but she doesn't realize that we're still picking up their conversation. Yikes.
I think last part is we haven't finished the colloquy, so we can just finish that, just so that's on the record, and then we don't have anything to add after that.
Okay. I don't see why this would produce a significant delay. If your client comes back competent, I want to, last time you were here, you mentioned needing a lot of time to be ready. But I just want you to think about this, and maybe you want to brief it, is if she represents herself, I don't think she should be forced to waive time in order for advisory counsel to be ready. I think she can go to trial as soon as she's ready if she's representing herself. And I don't know if you disagree with that. And you don't have to address it today.
We don't have to brief her at all. We agree with the court's conclusion, and that's if she were going to proceed to trial under her speedy trial rights, that's the chance she takes going forward. We would always prepare ourselves the best as possible under the circumstances, but that shouldn't factor into the decision as to whether someone represents themselves.
I agree.
I think the court always spends bounds on that, if that's what the court's thinking. I'm not saying it is, but
No, you had thrown it out last time that you would need a significant amount of time.
Dude, it's so fun to see court reporters type. I wanna see what their keyboard looks like and how they do it. It's so interesting to me. And Lori Vallow still wants to represent herself? Oh God.
Be ready even if she represented herself. And when I was reflecting on that, I was thinking that I didn't know the case. So I'm glad that we're on the same page on that.
Before the court goes forward with what I believe it's going to do, I would like the court to make a factual finding and a legal conclusion as to why the court feels it has the authority to do what it's doing and the facts that support that.
All right. I think I already have repeatedly.
I would ask the court to do that again, so make it perfectly clear for the record.
All right. Her prior attorneys requested a Rule 11 based on their observations. In their motion, they cite that she's, in their opinion, suffering from some form of delusions. Next, she's been previously, in their motion, found incompetent in another jurisdiction and went through a restoration process. By her own account here today, she was in that for approximately 10 months, which seems, I know it's a different jurisdiction and it's a different standard, and but it seems that anyone that's in that process for 10 months is a significant period of time before they're determined to be competent to stand trial. So based on those factors, I think there's definitely enough to continue with the Rule 11 process. All right.
So the state has one concern.
Man, these camera people, oh my gosh.
Go ahead.
Counsel has pointed out that they are not happy with the appointment of Dr. Hernandez. Dr. Hernandez did not go outside of the record to review anything. She indicated she had seen something on TV regarding the defendant, and it did not affect anything she was going to do in this case. However, if defense counsel is not comfortable with Dr. Hernandez being appointed, perhaps the court could appoint a different doctor. Most importantly, Judge, specifically due to the basis of the finding of incompetency in Idaho that we just found out today, I think it's incredibly important that the doctors actually speak to the defendant, because the records from the jail may not bring up the issues unless they're specifically discussed. So the doctors would, of course, inquire into those areas knowing that that is of possible concern. So it is incredibly important that the defendant cooperate and speak to the doctors. Defense counsel did indicate that it's common to stipulate to one doctor. That is not the case. I have been doing this for 20 years. It's not.
Sorry, there's something in my eye. It's like bothering me.
We do. We are protecting. We are protecting the record, Judge, so that we don't come back on appeal for ineffective assistance of counsel when they say it should have been.
Did Lori Vallow just speak just now? Was that her?
Evaluated, and it wasn't.
Can I add one last point?
Or is that the attorney?
And again, this is going to go on for a little bit longer. Even if she does go to trial in February, this case is going to go on for some time. Everybody in this courtroom is going to have an opportunity to see Ms. Vallow, to talk with her. And if there are any issues about protecting the record, it can also be done then. I understand this might be a little bit more convenient, but what we are saying is at this point, it's not necessary.
Okay. Are you requesting a different evaluator?
Yeah, we were going to, yes.
All right.
We're going to do the Rule 11.
We thought the Rule 11 doctor had to do it, so we weren't going to bring it up.
Well, I think I can do it. What was the name of the one?
Dr. Camille Hernandez is the doctor, and we would request that Dr. McGady be ordered to visit the defendant again because of this unique circumstances. He did indicate in his report that his opinion was not as sure as it could be had he been able to interview the defendant. So the state would request that Dr. McGady reevaluate the defendant with an interview, and that this court order the defendant to cooperate to the best of her ability.
Do you want to be heard?
You hear that chuckle from her? All right, well, spoiler alert. Judge denies request to cancel mental health evaluation.
We're going down the rabbit hole at this point.
I know,
far
just
afield from
kidding.
what the court's concerns are that you're able to represent herself. Now we're discussing all of the things that are relevant to Rule 11, which I'm indicating to the court aren't necessarily probative of what you need to understand in order to make a determination whether she can represent herself. If she doesn't want to talk to the doctor, she doesn't have to talk to the doctors. That's pretty straightforward and clear.
You're not requesting a specific doctor be appointed in place of Hernandez. You're talking about McGady was the one that found her competent?
Correct, but was not secure in his findings. So we would just request that. And then if you just notified
the forensic services unit, they will appoint another doctor that does in-custody evaluations, and she can be evaluated pretty quickly.
Okay.
One last thing, Judge, we never asked, did the court read the, basically file a motion to reconsider, including the both reports, or read those?
Read what?
The reports.
I haven't seen any reports. No.
File a motion to reconsider with the reports attached. I think the court probably should have reviewed those before we had.
You filed a motion to reconsider what?
You filed it under seal.
When was it filed? Are you talking about the motion to reconsider your motion to withdraw Rule 11?
Yes, that we hand-delivered last week, I guess it was.
Okay, I issued a ruling that said there was nothing to reconsider because I had neither granted nor
We weren't sure what
denied the motion to reconsider, or the motion to withdraw.
When we left court last time, the court indicated that it would like additional information to make a determination. That's what we provided to the court via those reports that the court asked for. You asked for those reports. We objected to going back to Rule 11, but it was determined at some point that there may be some outstanding reports. That's why we set this hearing. That's why we sent you the reports so you could review them before this hearing.
The state often his opinion, if he didn't feel like he had enough to make his opinion, he shouldn't have made his opinion. The state often relies on these opinions as is, so I don't see why this case should be treated differently than is normally treated. So he made his opinion based on the records review and his brief interaction with Ms. Vallow or Daybell. So I don't know how, once I make that appointment, how quickly they schedule those.
Within a few days, I believe.
Okay.
Laura's gonna be so mad when she sees the footage. Hit the mute button.
So if she's found competent on the second evaluation or opinion, we should be set back here in short order, and we'll talk about where we're going to go next. Is there anything else?
No, I think we just wanted to make sure on the record, so you're denying our motion to withdraw and then ordering that she complete the Rule 11 process.
Yeah, I think that's the safest course of action for the purpose of appeal issues, and once we started it, I think we just need to finish it.
And I wonder how many mental health evaluations she's done.
Oh, yeah. Say what?
Anything else from the defense?
Court date then after the
That's what I'm, because we have a court date with Rule 11, December, I think, December 5th. So I think that would be enough time for this.
Well, next week, is it next week that's a short week?
Yeah, it's a short week.
I agree with you. I think that date should still work. And if she is deemed competent and the parties stipulate to competency, you can contact my judicial assistant and we can set it in short order on this calendar.
And just, is the state, just so we're clear, is the state going to be willing at that point then to agree to she's competent? We're just assuming that the state will stipulate that.
I don't know. I guess it depends on what the report says. I mean, I agree with you that sometimes the state does stipulate on one report, but there's not a requirement that they have to, so I can't force that stipulation. But I guess we'll see what happens on the next report.
I think the absurd end result here is if the state doesn't want to stipulate, then we're going to have a hearing where The defense is basically saying she's competent, and then the state's insisting that she's not competent?
I don't know. I guess you're going to have to wait to see what the next report says.
Oh, your water bottle.
All right. Anything from the state?
No, Judge.
All right. We'll be recessed on this matter. Oh, wait. Prior counsel, since we're here, prior counsel filed a motion to compel.
yeah.
The state just filed a response.
Well, since we're in Rule 11, isn't everything suspended?
Well, were you urging that motion the prior defense counsel filed, and are you going to file a reply? That's all I really want to know.
We're still reviewing that, Judge. Obviously, we still have to catch up on all the stuff.
Okay.
And also in terms of if Ms. Daybell's going to represent herself, that would be something she might want to respond to instead of us. All the deadlines should be stayed because of Rule 11. I realize the state had a deadline that they'd asked for an extension, and that's why they filed it. But the reply, obviously, will come after the Rule 11 process.
All right. That's fair.
Yes, I think maybe if we could ask for the...
So they keep saying Rule 11, Rule 11. So in Arizona, a hearing may be held when a defendant is suspected of being mentally incompetent. And she wants to represent herself.
3-day reply deadline to start when we figure out where we're at in this process.
That's fair. That's fine. Okay. We'll be recessed.
Also, how does she have access to getting her hair done and her face done? All right, well, that was Lori Vallow. Yeah, she represents herself. You know what? If I will watch the trial if she represents herself. Usually when people represent themselves, I'm like, I don't know, I want to watch this. It's going to be a hot mess. But since we already know the outcome of the major trial with the murder of her 2 kids and Tammy Daybell, for this one, I mean, honestly, she's going to be locked up for life anyways. But you never know, right? Things can happen to PO. Maybe things can be reversed. So it's good to hold people accountable for all the crimes that they committed. But yeah, if she represents herself, I will, I'll watch. It's going to be a hot mess. Oh, yo. All right, y'all. That is it for today. So today we covered Karen Reed, went over the Karen Reed hearing. And then, I haven't seen this video, so I was just curious about Lori Vallow. I wanted to hear her talk in the courtroom. But I think they said they'll be back on December 5th if Lori Vallow is found competent after she does her other mental evaluation. We'll see what happens with that. I mean, when she was talking in court today, she sounded normal, right? She sounded normal. But maybe the unhinged will see, it will leak its way out when she's representing herself. Opening statements, maybe. Direct examination, cross-examination. Yikes. All right, y'all. Well, that's it for today. I hope you guys have a good one. I will see you guys next Monday for the Sarah Boone sentencing. I think they said it was going to be rather short, maybe about 2 to 3 hours long. I did see that they already did the pre-sentencing investigation for Sarah Boone, but we can't access it. That is, it is sealed. And then after Sarah Boone, the week after that, back to Karen Reed, and then maybe Lori Vallow in the same week of Sarah Boone. We'll see. But a lot of cases are pending, and hopefully trial 2025. I think 2025 we have, let's see, where is my course schedule? 2025. Possibly Karen Reed in January or April. Lori Vallow / Daybell scheduled for February. April, Corey Richards. That's the one where I'm the most. Oh, the Corey Richards one. I'm very I'm excited for that one. That one's a crazy trial. Corey Richards is a wild one. That's in April, and then also Idaho. For the Idaho student murders. That's in August, November. That's going to be a huge one too. But, I feel like with that one, I don't know. There's a lot of things happening there. I don't know if I really believe the trial is going to really happen in August. I don't know. What time does it start? On Monday for the Sarah Boone sentencing. Do I not have the time? Sarah Boone. Oh, I don't have the time up. Here, let me look it up really quick. Sarah Boone sentencing. Sarah Boone. I'm not a robot. Yeah, the Corey Richards one. Oh my goodness. Crazy. I requested some docs on the Corey Richards stuff. And that will be very interesting. She apparently called her attorney at the time, Sky Lazaro, a dumb bitch. And I'm like, why would you call your attorney that's representing you, that's fighting for you in the courtrooms, a dumb bitch on the jailhouse calls? She's obviously going to have to listen to your jailhouse calls because you know who else is listening to the jailhouse calls? The state. They're listening to it. It's just like, just doesn't seem very smart. You know, Corey Richards, oh man. All right. Pre-sentence investigation. What time? 1:30 p.m. Oh, good. 1:30 p.m. So that's like 10? Or is that 11 my time? 10. Yeah, that's 10:30 my time. Cool. Not bad. So I will see you guys 1:30 p.m. Eastern time zone for the Sarah Boone sentencing. And again, pre-sentencing investigation. But it is sealed, confidential. But it'd be very interesting to see what she says during the pre-sentencing investigation, because I think she is going to speak. I think she testified on the stand, right? I think she is going to speak, but will she say that she's sorry, or is she going to say, it's not my fault that I did it? Hey, Addie, how are you doing today? Yes, happy Thanksgiving. You guys, I hope you guys have a happy Thanksgiving. I know if you're Canadian, you guys already had your Thanksgiving last month. But yeah, I hope you guys have a happy holidays. Take care. I will see you guys next week. Or, you know, unless something else pops up during this week, maybe I'll see you guys again. Who knows? Sometimes the random streams just be happening. But I think I'm going to... Let's see, what should I do? I think I want to stream on Twitch either today or tomorrow. So for those of you guys on Twitch, there's this game that I want to play that looks kind of unhinged. So maybe I'll see you guys today or tomorrow. But yeah, I hope you guys have a good one. Take care. I will see you guys later. And goodbye. Take pictures of all the craziness, the Black Friday stuff, sales. I got my air fryer. That's what I wanted. I got my air fryer. I want to get a hose. So I'm trying to look for the Black Friday deals for a hose. I want to get a new hose for the front of my house, for the back of my house. And then happy Thanksgiving, my American buddies. Wait, Tam, are you Canadian? Home Depot got some sales. Yeah, I'm going to do all the online stuff, though. I don't know if I want to go in there in person. Maybe just order online. You get emails from them? Okay, yeah, I want to get a hose. I actually have a list of the stuff that I was looking for Black Friday. I want to get curtains. I want to get a new rug, but I don't know if I want to, because rugs and curtains are kind of a headache to shop for, so I don't know if I want to go through it. I want like new like bed sheets. They're so expensive. There's this like ceramic cookingware that I really want to get. I think they're 35% off right now. There's a TV stand that I want to get. And I swear to God, I don't know if they ever go on sale, but I messaged their Instagram because I've been subscribed to their website for like a year now, and I haven't seen any sales happen. So I DM'd them on Instagram. I was like, hey, do you guys ever do sales? What's up? What's going on here? Oh, you're Canadian. You live in Vancouver Island, BC, Canada. Vancouver is same time zone as me, I think, right? Same time zone as California. Don't forget about Cyber Monday. Yeah. I don't know. I'm going to be so upset, though, because a lot of these companies that I bought so far, they're like, oh, this is our Black Friday sale. So if they do a crazier sale on Cyber Monday, I'm going to be pissed. Because the way they advertise it, they made it seem like it's going to be the same sale. So buy now. But maybe they tricked me. I don't know. Maybe they did. All right, y'all. I hope you guys have a good one. Take care. I will see you guys later. It was nice hanging out with you guys again. And I will see you next Monday on YouTube and then on Twitch. Maybe today, maybe tomorrow. We'll see. Bye, guys. Have a good one.